A man pulled over his own car on US 85, not because he was speeding, but because a deputy was. Then minutes later, he was arrested. And more minutes later, he was released. And then months later, he received an $80,000 payout without ever even filing a lawsuit. Hey, I'm America's attorney. I've been a lawyer for 24 years. I've helped almost 3 million people. Let's break down what led to Barry Zatkalik's arrest and his pre-lawsuit settlement. The man at the center of this case, Barry Zatkalik, is a former reserve officer with the Denver PD who decided to pull over his own vehicle and begin recording after noticing a deputy speeding on the interstate. The incident took place in February of 2024 when Deputy Walter Berlinski from the Adams County Sheriff's Office was finishing a traffic stop on southbound US Route 85 near the 104th Avenue in Adams County. Zatkalik's status as a former law enforcement reserve officer adds a layer of context to his decision-making. He was not just like some random passerby, but someone with familiarity in how policing should be done. As Zatkalik explains, handcuffed in the backseat of a police cruiser, the deputy allegedly sped past him on southbound US Route 85 without lights or siren, a driving style Zatkalik believed warranted internal review. Zatkalik states that he paced the officer and recorded him 80 in a 65, no lights, no siren, no justification.
I started to go to catch up to him because I wanted to pace him to see how fast he was going. He was going about 80 miles an hour. I recorded it.
After that encounter, Zatkalik came across the same officer conducting a traffic stop. He pulled over specifically so he could record the deputy and gather details for a formal complaint. When Berlinski noticed that he was being recorded, he approached Zatkalik's vehicle and asked what he was doing.
Everything okay?
Yep. Can I get your name and badge number?
For what?
What?
For what? What do you need?
So I know who I'm making a complaint against.
For what?
For speeding.
Speeding?
Yes, sir.
Okay.
I have you recorded doing 80 miles an hour in a 65 mile an hour zone.
Okay.
No headlights, no sirens, nonchalantly. Apparently you drive like that all the time. So I wanted to film hypocrisy at its finest.
Okay.
The footage shows the deputy's tone shift as Zatkalik repeats that he is within his rights to film and that he wants the deputy's name and badge number.
Okay. License, registration, proof of insurance.
No.
Yes.
No.
Yes.
No.
Because now you're in.
No, I'm
Yes.
doing nothing. If you're going to start this, you get your sergeant over here.
License, registration.
Get your sergeant over here.
License, registration.
Get your sergeant over here.
License,
Get your
registration.
sergeant over here.
Deputy insists Zatkalik has no reason to be there and begins framing the situation as interference, even though Zatkalik is seated inside his own car, not standing on the roadway, recording from a distance, not approaching the scene, exercising his rights, not breaking the law. The body cam footage shows Berlinski becoming increasingly irritated as Zatkalik continues recording and restating his complaint intentions, setting the stage for the arrest that follows just minutes later.
I'm asking for your sergeant for the last time.
And I'm asking
Get
for
your sergeant out here. Well, you ain't getting my
license,
You ain't getting my You ain't
proof.
getting nothing.
What triggers the escalation is not a safety threat, a traffic violation, or any involvement in the underlying stop. It is Zatkalik's act of filming, his criticism of the deputy's driving, his attempt to file a complaint. The deputy quickly reframes the situation as interference, and as the discussion intensifies, he orders Zatkalik to step out of the vehicle, stating that he is being detained for obstruction. When Zatkalik warns the deputy that he will sue if he's arrested, Berlinski immediately pulls the door open to remove him. The body cam footage shows the deputy taking Zatkalik by the arm, directing him out of the car, and handcuffing him on the roadside. After Zatkalik is placed in the patrol car, a supervising officer arrives and reviews the exchange.
How exactly did he obstruct? Well,
That's what we got to clarify.
yeah. Well, I'm trying to get it. He came up here. If in all honesty, I should have contacted him sooner, but I didn't. I waited for my traffic stop, so I contacted him. He's video recording me, so I was asking for all of his information. He was like, he's not giving it to me. He wanted a supervisor.
He was just video recording?
And then when I was asking,
Did he walk up to your stop?
No. But then,
You don't have obstruction?
but when I was trying to get his information here,
Yeah. Right.
he wouldn't give me his information here. He wouldn't identify himself here.
The deputy supervisors inform him that he did not have probable cause to conduct that arrest. They released Zatkalik. And then they forced Berlinski to apologize to him.
Well, here's my business card. Didn't mean it to go this route. Unfortunately, it did. So that is my, my apologies. But so I don't know what else to say.
You ought to know better.
So I will bite my tongue on that response, sir.
Yeah. I'm Am I free to go?
Absolutely, sir.
What makes this incident more than a bad arrest is that the core of Barry Zatkalik's conduct, recording a deputy and preparing to file a complaint, is explicitly protected by the First Amendment. We know this. Long before this traffic stop encounter, federal courts had already recognized a constitutional right to film police officers performing their duties in public. Most importantly for this case, the 10th Circuit Court of Appeals, which covers all of Colorado, issued a landmark decision in Irizarry versus Yahia 2022, holding that the right to record police was not only protected speech, but was clearly established. The court emphasized that bystanders may record officers from a reasonable distance even during traffic stops, and that officers may not retaliate against individuals simply because they are filming them. So Zatkalik was doing exactly what Irizarry protects. He was seated in his own vehicle on a public roadway, recording a deputy, gathering, identifying information, preparing to file an internal complaint. Nothing in the body cam footage suggests that he interfered with the stop physically or that he obstructed the officer's ability to perform his duties illegally. This is precisely the type of retaliatory arrest that the First Amendment forbids. A situation where an officer detains someone not because of a legitimate law enforcement need, but because the person is documenting the officer's conduct, criticizing the officer's conduct, or questioning the officer's conduct. Remarkably, the $80,000 payout to Barry Zatkalik came even though he never filed a formal federal civil rights lawsuit against Adams County Sheriff's Office or Adams County government. Instead, his attorney sent the county a legal demand letter that laid out the video evidence, the deputy's conduct, the supervisor's on-camera apology, and the risk of a clearly established First Amendment claim that actually looked pretty strong. Although a demand letter has no independent legal authority, counties and police departments can take them seriously because they function as a preview of litigation, especially if they come from a lawyer. As a sidebar, don't write one yourself, get a lawyer. If you have a lawyer write your letter, it signals that you as a claimant have legal representation, that you understand the constitutional framework, and that you possess evidence strong enough to survive motions to dismiss and summary judgment. 9 News reports that after that letter, the county agreed to settle the matter, paying Zatkalik the $80,000 in November of this year, rather than endure protracted litigation. The decision by Adams County to resolve the claim without formal suit underscores how the video record and the supervisor's acknowledgement placed the county in a vulnerable legal position. By settling, the county avoided a public court decision that might have further crystallized liability under the First Amendment in the 10th Circuit. According to the reporting, the supervisor's body-worn camera apology and the absence of a credible defense left little practical alternative but to accommodate the demand. From a practical standpoint, the settlement shows how agencies increasingly opt to resolve potential Section 1983 claims arising from citizen recordings before they go to court. Instead of defending an arrest that arguably lacked a legal basis, arguably, it really lacked a basis, whose footage undermined the department's justification, whose supervisor acknowledged the violation on camera, the county just put the matter to rest. The outcome sends this message. A well-documented recording plus an admission of wrongdoing can lead to significant liability without a full trial, without years of litigation, without a jury ever hearing the case. Now, in this situation, $80,000 functioned as the county's risk management decision, and a little bit like a formal apology.
That's what the money is for!
The aftermath of Barry Zatkalik's arrest highlights how accountability inside a sheriff's office can hinge on something as simple and powerful as a body-worn camera. The supervisor's immediate apology, captured on the same footage as the arrest, made it virtually impossible for Adams County to maintain that Berlinski had acted lawfully. The fact that Adams County agreed to pay $80,000 without a lawsuit underscores how costly it can be for agencies when officers retaliate against someone for recording or questioning their conduct. Looking ahead, what remains unclear is whether Adams County will impose any formal discipline on the deputy involved. Do you think that the settlement is enough? Or should Berlinski face professional consequences? Hey, do me a favor, drop your pro se opinion down below in the comments and let me know what you think. And don't forget to lawyer up with me, America's attorney, by hitting that subscribe button. I will be back soon with more legal breakdowns, and I will see you then.